I'm Jeff. Hello. I was here last year. I really enjoyed it. Thank you for having me back. Love the city. Love the community. I am from Missouri, like right in the middle of the United States, very, very far away from here. Notwithstanding what this talk is about, I actually am a tech person. I'm a cloud consultant and software architect. I work for a company called Worldwide Technology in the States. But in addition to all the other things I do, I am also a lawyer. It's not contagious. You won't catch it, okay? Very importantly, not only am I a lawyer, this is the most important slide in the whole deck, okay? I'm not your lawyer. I'm licensed to practice law in the United States, in Missouri, and more importantly than that, your lawyer is your friend. You love your lawyer. You love your company should love its attorneys. I don't know how it is here. In the US, we make fun of lawyers a lot, and nobody likes them. I don't really even like them. But your lawyer is ethically obligated to care more about your best interest than their own. Right? So the situation in a talk like this, we're going to talk about some legal concepts, some legal issues around open source software and the licenses that we all use every day, but I don't know most of you, and I don't know enough about your specific circumstances, right? So if you have questions, there's the Slido app for build stuff. So if you have questions, throw them in there. We can talk. I'll be here the whole rest of the week, so we can talk about it. Just realize I'm not your lawyer. All right. So open source software, why does this thing even matter? Like, why do we care? There's a lot of great talks, there's a lot of great technologies we can learn about at a conference like this, and this is a talk with a lawyer talking about licenses, right? Why does it matter? So, who here builds software today that doesn't use any open source at all? Right. I see 0 hands. It's possible there's someone that just doesn't want to raise their hand, but really no one. We're all using open source every day. I'm a .NET guy primarily, so there was a time when people in the Microsoft developer community felt like they didn't use very much open source, but even .NET Core and all the Azure tooling, almost everything we use today has components of open source in it. So to really do that in the right way, to use those things in a safe way for our organization, our project, our clients, we have to worry about how this stuff works. Now, I like to take a start by laying sort of a level the playing field and make sure we're all on the same page about the stuff we're going to discuss. Before we talk about the licenses, I'm going to talk about a lot of the major licenses in open source, but first off, what even is this thing? We talk about open source software. What is that? What does that even mean? Does anyone want to take a stab at it? It's okay, throw your hand up and say, what does it mean to be open source? Otherwise, I'm just going to point at somebody. Yeah.
Is it basically where you publish your source code to be reused for other people to reuse it?
Oh, that's actually pretty good.
Give them access to the source code so they can use it or make changes themselves?
Yeah, that's pretty good. Right. That was actually pretty comprehensive. That was good. So he said where we can share source code with other people who can then change it, do things themselves, and that's really good. There's usually one other answer I get. That people say, oh, it's free software out in the community, right? Those are the two things I usually hear. Neither of those things is strictly speaking wrong, but open source software means something very specific. Open source software is software that you receive under an open source license, open source very specifically, and an open source license is one that specifically is going to include certain key aspects. There are differences between how all these licenses work, but an actual open source license is a license that at the very least is going to provide for free redistribution, source code inclusion, derivative works, non-interference, non-discrimination. Those are the things, the primary things that make up what an open source license is. Let's talk about all of those. Free redistribution, right? You didn't say this one, oftentimes people do, and they say, it's free. Sure, open source software is free, but when we say free software, or the more inclusive term of free and open source, like FOSS, what we really mean is free as in free speech, not free as in free beer. Okay? We mean freedom of information. So in the early days, before there even was an open source definition or a real term of open source software, people like Richard Stallman and others in the freeware, the free software community, had a belief that if you are executing software on an environment or on a machine that you control, you should have the right to understand what it is that it's doing on your machine and in your environment. That information to you, the access to the code, should be available to you so you know what's happening because you're running it on your stuff. Okay? So open source software is always free in terms of information. It may also, sometimes, often, but not always, be free as in free beer as well. Sometimes you get it without paying for it. Now, source code inclusion. Yeah, right? GitHub. Okay? We get source code, we get access, we get to see and pull down the source of the thing that is we're using. I download an open source library, and I take a look, and I can kind of see how it works and play around with it. But here's the thing. Understand that when we say that source code is included and available, I think most of us understand that the ones and zeros, the machine code, or whatever else, that's not source code. But is anyone a JavaScript developer? Come on now. Anyone play with JavaScript even if you don't want to accept that you're a JavaScript developer? Ah, everybody. Okay, right. This is also not source code. Stuff that we throw through an obfuscator, or even stuff that we build and run through Babel, or TypeScript that we then run through the transpiler to output readable JavaScript. The output of the TypeScript transpiler, the output of Babel, is not your source. The source code that you have available to you, or the source code that you're expected to make available to consumers of your open source, is the code that was written in the way it was written by the developers who built the thing. Even if there's some other intermediary version of it that is perfectly readable, or this. Okay? Derived works. This one's kind of interesting, because it's comprised of two different things. Derived works is a combination of the right to modify. I'm just going to keep pointing to you because it was really a good answer. Like, it was more comprehensive than I usually get. The right to modify the software that you receive, to make changes to it. And then the right to redistribute that thing. This is different than free redistribution from part one. Free redistribution, the free information, not free beer, right? Free isn't free speech. That's, I can take the thing and freely redistribute that same thing elsewhere. I'm also allowed to make something else from it and distribute that thing. Okay? Now it raises an interesting question, because what does distribute even mean? And it matters because when we start talking in a few minutes about the different licenses, a lot of times the requirements, especially if we're talking about things like GPL type licenses, a lot of the requirements that fall on you as a consumer and redistributor of open source, a lot of those obligations that you have come into play upon redistribution. So when have you redistributed something? If you are building internal tools for your company and it's being used by hundreds, thousands of people, all inside your company who are employees of your company, working on machines owned by your company, then figuratively speaking, the software has never left the four walls of the organization. You've not even distributed something. If you share it outside, you share it with third-party contractors who maybe aren't employed, who are working for you with your dev teams, but they're not employees of your company, they're working on their own stuff. Now you've distributed software. It's possible that you have distributed open source. You have to keep that in mind. Similarly, what about we live in a world where everything is SaaS now, not just SaaS and PaaS and infrastructure. Everything is as a service. Well, depends. If you're operating an API in the cloud, it depends, by the way. If you do ask questions later, understand that it depends are the two most commonly used words by lawyers in the world. Okay, so understand that. But it depends on what license you're using. Right? Because most licenses, but not all, say that if you're executing code in a cloud environment that you control, and you're simply allowing access for others to write their own applications that hit your API, the API that's executing up here in the cloud is not running on your consumers' machines. You've not distributed software. You haven't distributed open source. But remember that still you're sending some stuff down. It's not just data. You're sending HTML maybe or JavaScript or whatever else. You're still sending some things down that then execute in the client's environment, and that has been distributed. Same thing with a mobile application. Everything's mobile today. So it could be that what you have an application, like a suite of projects and software components. Some of them are running on your servers or in your cloud centers, wherever, in Azure, AWS. Some of them are running on your client's machines. So you got to think about where that software is going to live, because that could impact the decisions you make about using open source software. Okay? Non-interference. Non-interference is basically about neutrality. What I mean by that is an open source license. If you receive software under an open source license, that license cannot and will not restrict you in terms of how your software interacts with other software that it is distributed alongside. Look at this in a diagram, a really simple-ish diagram. If I build software and I incorporate a couple different open source libraries into it, and I make a big package of software, and I have a derivative work here, it may be, again, we'll talk about GPL in a few. It may be that some of this is maybe GPL, and this distribution down here, this derivative work, may be open source. But there will be nothing in the open source licenses that stop me from distributing this open source piece of software alongside other independent software that may be proprietary or closed source. There will be nothing about the license that says you can only distribute it in a way that will work on, say, an open source operating system. It can only work on Linux. It can't work on Windows. That would be interference. Open source doesn't allow that. Okay? And lastly, non-discrimination. Discrimination can be a loaded term, mean a lot of different things. In the case of open source, we really mean any kind of discrimination, but most specifically, discrimination of purpose. So take, for example, a scenario where maybe I work for a banking institution, a financial institution. And I build up some stuff, and I decide, and my team decides, we have this financial engine, this calculator over here that is really interesting, and we think we want to take this piece and carve it out and share it with the community and let other people use this engine. So we're going to take this piece and make an open source library and put it out there. But we want a license that says you can use it for whatever you want as long as you're not a bank. You can use it for whatever you want so long as you're not going to use it in some software that now competes with my business interests. Well, that's discriminatory. That's not allowed. You can use the thing I build for whatever purpose you want. In fact, at one point, Douglas Crockford, I know some of you will know who he is because you said you weren't JavaScript developers, but when I said who's touched JavaScript, is that okay? Douglas Crockford tried many years ago, he wanted to suggest a new open source library that said, you can use it for whatever you want, but you can't use it for evil. I don't know, I'm a Harry Potter buff. I have no idea how well Harry Potter is loved anywhere else, but I'm old and I love this stuff. So, even though he said something as seemingly reasonable as not for evil, the open source initiative came back and said that's not okay. If Voldemort wants to take open source software and tools and build something that does terrible things, there's nothing about an open source license that can stop him from doing so. Now, that doesn't mean he won't go to Azkaban, because when we are talking about open source software, we're talking about intellectual property law. If he actually goes and kills a lot of muggles and mudbloods with his software, he's still committing murder. So when I say non-discrimination, I mean the license itself will not stop you from doing anything. Other laws still apply. Because ultimately, what we're dealing with when we talk about open source software is intellectual property law. And nothing more. Not business law or any other form of contract law, not criminal law. Just intellectual property law. And in most places, including the United States and Europe, intellectual property law is primarily made up of three core components. Copyright, which is the way we protect works of authorship. Patents, which is how we protect novel inventions, useful novel inventions. And trademark, which is about protecting identity or brand. Now, when we talk about open source software and open source licenses, we are first and foremost talking about a license over copyright. I write a thing, I own it, I continue to own it, but I'm going to let you have it, and I'm going to let you have it under a license to use my copyrighted work, under some terms and conditions. Some open source licenses, but not all, Also, talk about patent. I've invented something novel and useful, and I have rights to it, some sort of patent rights, but I'm going to let you have a right to use this patentable thing, and I won't sue you for infringement. Okay? And none of them have anything to do with trademark. So just because you're getting open source software and getting the right to use it doesn't mean that you can assume the identity of the original authors of the thing. If you write something with .NET Core, you don't get the right to use their Microsoft logos around it and make it look like it's your stuff, or like your stuff is their stuff. You have no license to their trademarks at all. Okay. A couple other things specifically around what open source is. What about sale? Can I sell open source software? Yeah, some. I was thinking about, well, okay. So strangely enough, I know I said depends. Yeah, no, like totally. Totally. You can make, there are companies that make tons and tons of money selling open source software. There's nothing that stops you from doing so, because remember that when we talk about open source, there are two different terms that are commonly used to mean the same thing, but they do not. When we talk about open source software versus closed source, proprietary means it's something that you own that you don't share, a closed source piece of proprietary software. But just because it's open source doesn't mean it's commercial. Commercial is something you're putting into the stream of commerce, oftentimes selling for a price. Something can be open, non-proprietary software, but still be commercial software. Here's the trouble, though. I built some open source. I decide to sell it. And I sell it to you. And you say, great, thank you. And you turn around and give it away to somebody else the next day. I can't stop you from doing that under an open source license. I can't stop you from freely redistributing the stuff I just sold to you. You can sell it for $1 less or €1 less. You can give it away for free. So how does that work? How can I possibly make money? How can I possibly sell a thing that everyone else can give away for free? Thoughts? Support, right? So first off, take something like Red Hat. Support's good. You're getting a lot of things if you purchase, say, like Red Hat Enterprise Linux. You're going to get some other tools that are separate from the kernel itself, for starters, which may not themselves be open source, but they run nicely alongside it. You're getting this trademark, right? Like the trademark, the reason we protect trademark and brand is because you know you're getting Red Hat Linux, not Linux that's run by Jeff out of Jeff's mom's basement, right? You know what you're getting. You're getting warranties. You're getting support. Another way is consulting, right? You can be consultants around the thing. So we build open source, we distribute it, we make this stuff freely available, but then we have people ready to support you for a price that will help with integration, will help you get things working in your environment, will troubleshoot, will maybe be ready to fix patches and bugs in a way even more so than your standard warranty. Either way, the bottom line is when you sell open source software, if you've ever done so or if you ever plan to do so in the future, what I argue is that you actually do not. You don't sell open source software. What you're doing is you're plussing the thing that you have with something else of value. The open source itself, if you think that's what you're selling, you're not going to be very successful because someone else will give it away for free. So you have to figure out the thing of value, and that's really what it is that you are selling. All right. That's open source software generally. Let's look at a handful of licenses. First off, I made a brief reference to OSI. Open source licenses, let's take one step back to something I said near the beginning. When I say open source software is software you receive under an open source license, and an open source license is one that will be guaranteed to have those handful of things, the free redistribution and derivative works and all that. Those things are part of the open source definition, and the open source definition is managed and protected by the Open Source Initiative, opensource.org. They're the gatekeepers. So OSI, they're also, I think they even say on their site, they're not your lawyers or your support, but OSI are the people, the organization that helps define and drive open source for the community, and also decides whether a proposed license qualifies to be open source. When somebody suggests a license that says it has all these things as long as you don't do evil, it's OSI that comes and says, well, that's actually discriminatory and it's not allowed, so you can use that license, Doug, but it's not an open source license. Okay? And licenses generally run across a broad spectrum. Has anyone heard this term copyleft? A handful of people kind of nodding their heads. Okay? Open source licenses run across a spectrum from very permissive licenses to copyleft licenses. And really what that has to do with is the nature of whether and to what extent the thing that you are using has to remain open and non-proprietary in the future. So we're going to talk through across a spectrum of the 4 families or flavors of the most commonly used licenses: MIT, BSD, Apache, GPL, which collectively account for some 85+%, maybe 90% of all projects available on GitHub today. And in that order, because those, in that order, MIT, BSD, Apache, GPL, kind of run along the spectrum from the most permissive licenses to the most copyleft licenses. And when we get to GPL, we'll talk a bit more about what that really means. Because it's important, especially if we're using GPL copyleft libraries in our proprietary enterprise projects, as we'll see. So first off, MIT. The MIT license is old. The MIT license is older than the open source definition. We had MIT licensed free software or freeware before anyone had ever used the term or thought about what open source even meant. It came out of academia, right? MIT in the States. And the MIT license has a couple different flavors, but they all generally look like this. Now don't read this. It's a horrible slide with lots and lots of words. The point of showing this is actually that it's a horrible slide, but as legal documents go, and remember, make no mistake, an open source license is a license, which is a legal document. This is like a nursery rhyme, like a children's story. This is not a complex document. Really, all the MIT license says, this is a very permissive license. This first paragraph here is effectively giving you a list, and not an exclusive list, just some of the things you can do with this, including using it, modifying it, sub-licensing it, selling it. You can do whatever you want with this piece of software. The second 2 lines here are an attribution clause, saying, hey, you still need to make sure that when you redistribute this thing, and I know most of us don't do this, when you redistribute this thing, you need to include the copyright notices that were in the source code that you took that you redistributed. You need to include a copy of the license that you received when you redistribute your software. If you don't do so, you are basically stealing someone else's work and making it like it was yours. Don't do that, right? It's wrong, it's infringement, it's unlawful, it's ethically wrong. So we always give attribution. The other thing, this big giant thing down here that's in all caps, and this is, I don't know if this is a uniquely American thing in legal contracts or it's everywhere, but usually in a contract, the part that is the most important is in all caps like it's shouting at you, and I believe the reason we do that is because it's actually harder to read in all caps, and then we just sort of gloss over and say, oh yeah, and we move on. But this thing all boils down to these 2 words right here, as is. So it is a disclaimer of warranty. I'm giving you this piece of software. I'm giving you a license to use it, to redistribute it, to sell it, whatever. I'm not promising you that it does what you think that it does. I'm not even promising you that it does what I think it does. And that's okay, because guess what? It's open source, and if it doesn't, you can fix it. Right? So it's a disclaimer of warranty. Basically, every open source license at least has those 2 things. Even something as permissive as MIT, you should always be giving attribution and redistributing the licenses and copyright notices along with the software. And you should recognize that basically things are as is in almost every OSS license. Now the BSD license, also from academia, the Berkeley software distribution was an early or much earlier distribution of Unix. Again, this license is older than the open source definition. Berkeley is part of the University of California system, and the BSD license is very similar to MIT sometimes. But the thing with the MIT license is there's multiple different versions, and they're all in use today. So, and they all kind of say different things. So just because you see, oh, BSD, okay, that's fine, and you check a box, you don't necessarily know what the license says. And they have different kind of names, but what it boils down to is the BSD license or family of licenses can broadly be considered to be either the 2-clause version, the 3-clause version, or the 4-clause version. Most copies of them, in addition to like an introduction and have like numbered paragraphs, and there's going to be 2, 3, or 4 of them. Okay? The 2-paragraph version, the 2-clause BSD, is basically MIT for all intents and purposes. It has the attribution provision and the as-is disclaimer of warranty. Now, the 3-clause version, which I believe is the most commonly used, also has a non-endorsement provision. The non-endorsement provision says the following. If you produce something with my software, and then you produce promotional or marketing materials, advertisements, whatever, around the derivative work that you've made using my thing, you cannot include the open source authors, the BSD licensing authors, trademarks and names and things in such a way so as to make it look like that organization endorses your software. Or to put in slightly more layman's terms, I can't build, if I get something under this 3-clause version of BSD, and I tag and I'm using, take ASP.NET Core, whatever, I might be able to say, there might be able to be a Microsoft logo, but I need to be very careful to make sure that my promotional materials don't make it look like Microsoft stands behind my work. And that's okay, that's a good thing, right? Because maybe Microsoft makes great software and maybe you don't. Hopefully you do, right? Maybe I make some good license or some good library and you decide to use it, and now you've built something with it that's no good, and somehow people see the advertising that you put out and they associate this bad software with me as the author of this one library, and it harms my reputation. So that's what that means. Now, the 4-clause version says something that sounds like it's almost exactly the opposite of this. Okay? The 4-clause version also has an advertising provision, which says, but it's more specific, and I'm not going to even try to do the exact direct quote because I'll get it wrong, but effectively says that if you use something under the 4-clause BSD, your promotional and marketing materials, your advertisements must include the following phrase, and it's something somewhat innocent, something somewhat innocuous that says, this software was made using software developed by whomever. But nothing more. It's not an endorsement, but it's an acknowledgement. Now, this became really difficult. For starters, it's hard to square this a little bit with the endorsement clause, the non-endorsement clause, but also, over time, this was fine in the early days when not everyone was developing open source software, but now everybody is developing open source software, and everyone's using tons of it, and so we reached the point where you build something, and if you're going to use the 4-clause BSD and have marketing materials, you're going to end up with like a full-page, multi-thousand euro advertisement that just is basically a thank you list of all the other people who helped make this possible. It's not great. And it's largely not used anymore, but it's not gone. So if you see BSD, you still need to be cautious. Because if it's the 4-clause version, you may not want to use it. Okay? Both of these, I've already said, came out of academia. Early 70s, I believe. A lot's happened in intellectual property law in the United States, Europe, and other places over the last 20 or so years, which is that now we allow patenting of software in certain circumstances, certain places, and then we have companies who troll those patents and sit there and buy them up and then start suing people like crazy, and it's ugly and it's gross, but it happens. And so the MIT license, the BSD license, are silent on patent. They're copyright licenses only. If you get something under the MIT license, and it turns out that there's something patentable that becomes patented under an MIT library, you don't have a license to use that patented work. So many people, when I've asked before, who says MIT is their favorite license, the developers are, yeah, me, because I know that one's easy and I can do everything. Well, sometimes it's okay. Sometimes it doesn't give you what you actually need. The Apache came along, and they took what had been their version of open source, which was more like the MIT BSD stuff, threw it away, and released Apache 2.0, because we're all engineers and we have to version things, even our legal documents. So Apache version 2.0 of the license came out, and it is not a simple one-slide document. It's a huge legal document with defined terms and numbered provisions and all sorts of stuff. Not as easy to read, but one thing it does grant is a patent license, specifically. So if you get an Apache license library, not only are you getting a right to use the work, the software, the code itself, which is copyrighted, you are also getting the right to use anything that may become patented. And importantly, it also includes what in formal lawyer speak we call a patent non-assert clause, but in colloquial speech, we lawyers like to refer to it as a poison pill. And the poison pill says, not only am I giving you a license over this patent, but if you decide to turn around and institute patent litigation, if you try to troll this thing, I'm going to try not to fall off this stage right here. If you decide to troll this thing and come back and you assert patent rights and try to come back and sue the upstream contributors over this thing you've been licensed, your license terminates immediately and automatically. Not I have to sue you, I may have to sue you to defend it, but automatically from the moment you institute some sort of patent claim back against me, your rights to use my thing are gone. So we're trying to protect people both ways to make sure that if we're going to give those kinds of rights, because patents can be very valuable, if we're going to protect, if I'm going to give you a right to a thing, I'm also not going to come back and get burned by you or some other organization later. Okay? There are other couple things in the Apache license that are worth noting, like you have to have certain kind of change log requirements and things like that, but this is by far the most important aspect of the Apache license. And then lastly, we have GPL, free as in freedom. Sure. It's not a lie when we're talking about freedom of information. Okay, but GPL are truly copyleft licenses. So to go back to what that means and talk about it in a little more detail, what that means is when you use a GPL licensed library, that's fine. And when you create a derivative work with that GPL licensed library, that's also fine. And when you redistribute your derivative work, that's also fine. But that redistributed derivative work is also going to be licensed under GPL and will be open source. So these other licenses, MIT, Apache, I can take a thing, put it into my software, and I can close it. I mean, the original pristine code is available, I have to make available, but I can create a derivative work and build something proprietary. With the copyleft license, I cannot. Okay? With slight differences among the different types of GPL licenses. So really, when we say free as in freedom, GPL licenses are the most open. GPL licensed software is very open, but that also means that if we're in an enterprise setting, a business setting where we're trying to create proprietary things for our own business or for our clients, they're also very restrictive. This is not a judgment. So I want to be clear, because a lot of times people think, oh, he hates GPL. It is not a judgment. Like, there's no judgment of what is right or wrong here. It's all about the circumstances. It may well be that GPL is exactly right for what you're doing. But if what you're doing is trying to build a closed source proprietary piece of software in an enterprise setting, then it is not the right choice for you. Okay? Now, there are different versions of GPL, and they're all still in use widely. So again, we version these things. GPL version 2, I think, is actually still more widely in use in the wild than version 3. The differences here are pretty substantial. Version 3 does a lot of what Apache did. So if you see GPL version 3, it includes the patent licenses and the poison pill stuff and some of those things. It also did some things to allow better compatibility of GPL software with other software licenses. GPL version 2 doesn't have that stuff. Another thing that GPL version 3 did is, remember way earlier I was talking about what is distribution? And what if you're running an API in the cloud that is executing in a cloud environment or in Azure, something you control? Well, then most licenses say you haven't distributed. GPL version 3 makes it explicit that if you're running something that exclusively is a remote access situation, you're running the API, you're running this remote code, and someone else is just accessing it over HTTP or whatever, then yes, that's not distribution. LGPL, the lesser general public license, is a version of GPL that is what we call a weak copyleft. It's still a copyleft license, but if you have an LGPL licensed piece of code and all you do is dynamically link to it, right? I'm just going to pull it down and make a reference to it so I can use the namespaces, and that's it. Then that LGPL library, it's still open source. When I create a derivative work, I still have to make that LGPL library available under LGPL, but it doesn't infect. Again, that sounds like a value judgment, right? But it doesn't go in and trigger these scenarios where now your whole thing is open source. Okay? On the other hand, if you make a derivative work with the LGPL where you're actually modifying that thing you make, it still has to be open under LGPL. And if you statically compile in any way an LGPL library with your application, the whole thing becomes open source. Okay? And lastly, the AGPL actually closes the thing that got fixed by GPL version 3. The AGPL, A is for Affero. The Affero GPL says, yeah, even if you're running an API in a remote setting, and just let people access that API, that thing actually is still open source. You have distributed it, and you have created a derivative work. So that's a pretty dangerous license to use in most enterprise settings. The other thing about GPL, quickly, is that we have to worry about compatibility, which you don't have to worry about with a lot of other licenses. But compatibility asks this question, and unlike the MIT license, it is worth reading this one, even though it's a few too many words. Right? We say, can code under license whatever be combined and redistributed with code covered by GPL? And the question that's being asked here is, if I have some other stuff that's under some other license, does it add any further restrictions that reduce the openness of the derivative work beyond what GPL already allows? If so, those two licenses are not compatible and they cannot even exist in the same derivative work, because by including them together, you have violated the GPL. A couple examples of that would be Apache with GPL version 2. Apache adds a patent license, right? That's great. We're giving more rights to the user. But it also adds that point hill, which is taking rights away from the user. Well, that's bad. That's less open. And so as a result, you can't combine GPL version 2 and Apache together in the same derivative work. It's not okay. You just can't have them together. Any version of the GPL doesn't have the crazy advertising provision that 4-clause BSD has. So the two are not compatible. But importantly, sorry, go for it. Okay. Importantly, the slides are available on SpeakerDeck, by the way, as well, so they are out there and available if people want to find them. And I'll post a link later to them. Even if you have, imagine for a second, instead of just license X and Y, say that this was MIT and Apache and GPL 3, as an example. Those three are compatible, the first two are compatible with GPL 3, which means they can coexist, but the end result, the derivative work that we make, is still GPL. I can't redistribute it under MIT. It's still going to be a GPL copyleft derivative work when I'm done. All the compatibility means is I'm allowed to build it in the first place. Okay? So that's GPL. So this is usually, I'm actually okay. Good. So given what we know about the different key licenses, about what open source means, what do we really need to think about now if we are living in a world where we're working in big business, we're in an enterprise setting, we're going to use open source software, how do we manage that? And what do we need to think about? Well, for starters, got to think about contributions. If you decide to be the sponsor or author of open source, do you want to accept contributions? Other people can fork it. Now remember, just because it's open source, just because Microsoft has open sourced much of what's in .NET Core and a lot of the other tools they have, doesn't mean they're going to take your pull request. They take some, right, from some people. But are you going to take contributions from the community? Or if you are using open source and you decide you want to do something for that library in your setting, and now you want to submit a pull request to contribute back, that's great. Has anyone ever signed a CLA or a CAA before? Use those terms? A handful of people? These are similar but not the same thing. A CLA, which is more common, it's a contributor license agreement. Many larger organizations, if you are going to submit a pull request and ask to make contributions to an open source library, many large organizations will require you to sign this CLA. Because remember, when you fork the repo and you make some changes, whether it's fixing bugs, adding features, whatever, that work that you produced is your copyrighted work. You're the author of that. So when you make a contribution back, you may have to preemptively digitally sign a license agreement that says when you make the contribution, you are actually licensing your work back to the repo, back to the core team. So that you can't do a thing and then accidentally find out that other downstream users, consumers of that library, now have a problem because there's now works in it that the upstream author didn't have the right to license. Because the upstream author can only license whatever they have a right to. I can't license your work unless you license it to me first. A CAA, a contributor assignment agreement. Assignment is a fancy legal lawyer word for transfer. So a contributor assignment agreement means I made something with your library. I want to submit this pull request back to you, and you're going to take it. But in doing so, I'm not just licensing my contribution to you. I am transferring ownership of it back to you, such that I don't own that copyright at all anymore. Okay? So there's a subtle difference, but it's an important one. What about if you go and you check out a library, you find a repo on GitHub, and it's really cool. It's like, this is going to solve all my problems. I wonder what license it's under, and you look and you can't find the license text file. Like, you can't find a license. You don't know what license it is. Then what? It's right. So that is the answer I usually get. It's free. Yeah. So yeah, it is so not free. You can't use it. Okay? I build a thing, and this is important, right? I build a thing and I put it on the internet. Just because I put it in the internet and then you found it with a Google search doesn't mean you can have it. Right? You can read it. You can look at it and learn from it. It doesn't mean you can use or reproduce or redistribute my stuff. You find a thing on someone's blog and that person's blog doesn't give you as the reader a license to reuse those things. You can't use that code. You find a repo that has no license on it. It's informational only. You can't use it. There's no license because you don't own it. That's why GitHub helpfully recommends when you start a new repo, hey, what license do you want to use? Okay? If you're going to use open source, do you know who backs this thing up? Like, do you know where this comes from? Because again, maybe it's coming from Jeff's mom's basement. Do you know who supports this thing if something goes wrong? God, I hope no one's writing code in my mom's basement. Because no one in my family should be doing that. Do you actually know who's backing this thing up? If something goes wrong, do you know who's going to support it? Or furthermore, what happens if it just dies? Do you have a plan for that? Like maybe there's an open source repo. There's the example I like to use, and I don't think he's here yet, but he's coming this evening. Like Jimmy Bogart will be here. He wrote Automapper and Mediator, but he's one dude with a life, a family, a taxing job. What if he finally one day says, this has been great, but I just can't support this thing anymore, and it goes away? Do you have a plan? Is your organization willing to pick up the reins? Is your organization willing and able to manage that if it goes away, if the person who's been building it goes away? Now, in some areas, especially I keep saying I'm a .NET guy. In the .NET world, we have the .NET Foundation that helps kind of manage those things for large enough libraries, but not every ecosystem has those sorts of protections. So are you prepared? And do you actually know your future? So that's great that you're building software that's an internal tool today. That's great. But are you sure it'll only be an internal tool tomorrow? Is it possible you're going to decide you have something that you want to share with the world? Is it possible that at some point you're going to have a goal of an exit strategy where a company's going to come in and want to buy you and your software or your IP? And if that happens, have you made the right decisions and done the right planning up front so that you don't end up in a scenario where the acquirer, who may want to give you huge amounts of money, comes back and says, oh, we don't want to purchase this thing, because it turns out you may not have realized that, but you put this other stuff in here, and we can't live with that. So you got to think ahead a little bit to the extent you're able to plan for what you may want to do in the future, not just what you're doing today. Now that said, right, no question, we're going to use open source because it saves us time and money. It's dumb to write all of our software from scratch in today's world. Like, do not reinvent the wheel that has already been reinvented many times. Let's focus our developers and our team's energies on solving the problems that haven't already been solved in a useful way, and let the things that have been solved, like, let's leverage and stand on the shoulders of those people, those smart people who come before us, right? So, how do you protect against that? Well, there are commercial tools. There's things like White Source or Black Duck software. There are tools out there that we can use to, and I'm not affiliated with any of those companies, but who provide tooling that allow you to scan and check and get an audit trail of what's in your software. Depending on your needs, those things can be very valuable. They're expensive. Sometimes they're a bit alarmist and raise red flags where they don't necessarily need to be raised. So again, it depends on the nature of what your software is and how important that is to you. But a lot of times, if you just start with teamwork, you go a long way towards being in a better position than you are in today. What I mean by that is I don't start any new project without a thumbs up and a thumbs down list. And it's not a universal list, right? Because it depends on who the stakeholders are, what it is you're building. Every scenario is different. When I start something new with a team, it starts out with like, well, okay, we know for sure that these licenses are fine for our use, and these aren't. And if you find something else in the middle, ask the question before you just say yes. We developers don't want to be delayed, right? We don't want to be delayed in getting things done. Usually we're trying to solve problems that really need to be solved last week. So we don't like going and asking the team lead or the delivery lead or the product owner or the lawyers whether something's okay. But if we have a list that covers the main ones, maybe we're a little more willing, because we understand what's at stake, to ask the question when it needs to be asked. Or when I do a Google search and I see the very first thing in Google comes back but it's GPL, maybe at least look and see what the second hit in Google was before I just take the thing and move forward. Right? Ultimately, you just have to find out what the right tools are for your team. Because if you put tooling and frameworks and processes in place and you include everybody in the discussion and educate everyone, then ultimately everyone will go all in. People on your teams will care about this. This is a thing that not enough people in our industry care about, but it actually impacts almost all of us. Okay? So all I ask, first off, don't go become lawyers. It's not contagious and none of you have caught it. But do have a plan. Actually take the time to read a little bit about this stuff. Learn more about the issues that matter. There's tons of good material out there, not just on opensource.org. There are tons of resources out there to learn a bit more about these things. You find a new license, you can find information about it. And then when you start doing this, include everyone on the team, the developers, the tech leads, the architects, the business owners. Include everyone in those conversations. Because again, in doing so, you are empowering everyone on the team to make better decisions so that down the road, you don't find yourself in a scenario where you've built something of value, but because you didn't take the time to have the conversation up front, now it's too late, and you've got a thing that's a much bigger mess to solve in the future. Okay? Hopefully you all have a great week for the rest of the conference. Again, this is me. If you want to reach out on Twitter, this hashtag or email, I'm happy to have any conversations now or the rest of the week. Enjoy build stuff. Thanks, everyone.